Hello everyone, this is Ed Park, Managing Director at ATMS Logistics. Today we'll take a detailed look at the U.S. Customs form called Notice of Action or CBP Form 29. We plan to continue uploading video that covers various import-related topics in depth. So please like, subscribe, and turn on notification. The Notice of Action CBP Form 29 issued by U.S. Customs is a document issued by U.S. Customs to officially notify the importer of actions that are currently applied or will be applied in the future. In most cases, before receiving a notice of action, you probably have already received CBP Form 28, the request of information. Customs review the information you provided in response to Form 28 and then they issue the notice of action. We have a video explaining CBP Form 28 in more detail. A link will be provided for the reference. The main purpose of the notice of action is for Customs to modify or correct information reported on your import documentations. However, the notice of action can also be used to give the importer an opportunity to respond before certain actions are finalized. There are two types of notice of action. First action is a proposed notice of action. This is issued before the action is applied to inform the importer in advance. For example, Customs may notify you in advance if you plan to change a tariff classification, increase duty rate, or apply anti-dumping or countervailing duties, including the reasons for the planned changes. It is important to remember that you have 20 days from the date of issuance to submit additional information or comment. If Customs find the additional information or comments you provided to be valid, the notice of action may be resolved favorably. The second type is a final notice of action. This indicates that the action has already been applied by Customs. For example, you may receive notification that a tariff classification has already been reassigned, resulting in a different duty being applied. In most cases, reclassification by Customs result in a higher duty rate. If you receive a final notice of action, the changes listed are immediately effective. If you wish to challenge it, you must submit CBP Form 19 protest within 180 days. Filing a protest can be time-consuming and costly, so it is strongly recommended to take appropriate action during the proposed notice stage. We will also prepare a video explaining CBP Form 19, so please stay tuned, subscribe, like, and turn on notifications. Let's briefly look at the reasons why a notice of action is issued. First, Customs may request a change due to an incorrect tariff classification. For some product, multiple tariff classification may apply depending on who determines the code. Importers usually prefer the lower duty code, while Customs may require higher duty classification. Second, Customs may request an adjustment to the declared value of the good. Customs maintain the record such as the importer's past shipment history and declared value. For example, if a product was previously declared at $100 but is now declared at $50, Customs may request an adjustment based on prior records. Third, Customs may request corrections to country of origin information. If information submitted in response to CBP Form 28 is insufficient, customs may request corrections. Correcting country of origin information may result in losing preferential duty benefits. Customs may also require an application of anti-dumping or countervailing duties. A separate video on this topic will be prepared. Lastly, customs may deny preferential trade agreement benefits, like in this case of country of origin corrections. This may result in paying higher duty. If you receive a notice of action from customs, how should you respond? First, carefully read the entire notice and determine the type of action. Check whether it is a proposed action or final action. Next, review the reason for issuance of notice. Knowing why the notice was issued will help you prepare the necessary documents or solution. If it is a proposed notice, make sure to submit your rebuttal or additional comments within the specified deadline. If needed, consult with a customs broker or other experts for assistance. Finally, keep all records for 5 years. There are two key points about CBP Form 29 I would like to emphasize. First, submitting additional information or comment within 20 days during the proposed notice stage can help prevent additional duties or unnecessary costs. If the deadline has passed or sufficient explanation was not provided, and the action has already moved to the final notice stage, you must follow the formal protest procedure, which may incur additional time and cost. Therefore, it is strongly recommended to respond promptly to all custom-related matters. Today, we have taken a detailed look at the U.S. Customs Notice of Action CBP Form 29. We will continue to upload videos covering import-related topics in depth. So please like, subscribe, and turn on notification. If you have any questions or need assistance, please contact us at the email provided on the screen. We'll be happy to help. Thank you very much for watching, and we will see you again in the next video. Have a wonderful day.